Hello students, my name is Sunita Sridharan. I am a lawyer and a patent agent. I am also the founder and CEO of SKS Law Associates, which is a law practice specializing in patent law and which is based in New Delhi. Today I am going to talk to you about module number 39, Patent Law Remedies. This is a slightly tricky issue when we talk about the patent law remedies. What is a remedy? Under the law, if there is a problem, then we ought to be able to remedy that problem. And how do we go about remedying that problem? And what are the problems that the patent law envisages? We shall go through them very briefly today. Now, any kind of litigation set up for purposes of finding remedies is, as you know, lies in the courts of India. The courts of India, the civil courts and the criminal courts, that is the courts which have civil jurisdiction, criminal jurisdiction or both, are very clearly defined by the way the Code of Civil Procedure and the Code of Criminal Procedure handled a particular set of subjects. The rights that accrue in cases of rights and duties and finding remedies accrue from the Constitution of India. So right at the top we have the Constitution of India, under which we have the Code of Civil Procedure and the Code of Criminal Procedure, and then we also have the various acts which decide on how or what amounts to an offence or what amounts to a civil wrong. There is also the Evidence Act, which very clearly defines what can be taken by these courts by way of evidence. And apart from the various statutory laws, we also have the common law of torts, where again we may seek remedy when a court is deemed to be sitting in equity. So very quickly, to sum up, we look at the Constitution of India, which lays down the rights and duties. It very clearly talks about the right to approach the High Court by way of a writ petition, the right to approach the Supreme Court by way of a special leave petition, the Code of Civil Procedure, which governs civil cases that may be deemed to be civil offence under the various statutes, the Code of Criminal Procedure, which governs what can and what are the procedures for criminal cases as decided wherever the offences are decided to be a criminal offence under the various statutes, and the Evidence Act, which very clearly sets out what kind of oral or documentary evidence can be adduced in court in support of whatever the contentions are of the complainant and the defendant. And above all this, there is an equitable right which can be, for which a remedy can be sought under the common law of torts. Now, coming back to what are the rights under the Patent Act, because we are looking at a particular statute, and in this particular module we will be talking about the patent law. Very quickly, to touch upon the rights of the under the statute, one of the most significant, most important right is the right of the patent owner. As you are aware from your previous modules that you have studied, Section 48 clearly enshrines what amounts to the rights of a patent owner in cases where his invention is a product and also in cases where his invention is a process. So to quickly sum up, the right under the Patent Act of a patent owner is territorial in nature. It will extend only within the jurisdiction of India. The rights are subject to the exceptions laid out in the various sections, including section 47 and 49 of the Patents Act. The patentee of a product patent has exclusive right to prevent unauthorized third parties from making, using, offering for sale, selling or importing for the purposes that particular product into India. Similarly, the rights of a patent owner for process patent is the right to exclude a third party, an unauthorized third party, from the act of using, offering for sale, selling or importing for those purposes the products obtained directly by that process into India. Also, to quickly sum up the significance of a patent, and this is very important because law is evolving. As you know, law is never stationary, it is constantly evolving. The evolution of a law is directly dependent on social evolution, technological evolution, economic evolution, and how things progress. Law has to administer to the society and the problems that arise in society, or problems that arise due to various functions of a society, such as a technological advancement, and it has to deal with that in a particular manner. So, a remedy also has to be seen from the point of view as to what really would work right for a person who is suffering under this particular law. The suffering in this case need not always be the patent owner. It can also be the infringer. And we have to understand under what circumstances, what kind of defenses help a person alleged to be an infringer, and how does a person what kind of remedies are available to a person who is suffering because somebody has infringed his right. Now, to touch upon the significance, like I was talking, the exclusivity gives the patentee the time to work his patented invention and to make money. So, the underlying need here is to commercialize, and that commercialization, when effected by third party usage, can cause great harm to the patent owner, and therefore he seeks a remedy. A patent is seen as an award to the inventor for inventing something and contributing to technological advancement of society. So, every time there is a technological advancement, there is a requirement to understand whether there is any kind of infringement, because as you are very aware, in certain areas of technology, there are platform technologies and there is patent pools which are put together which create a particular technology. This is quite opposed to a patent which is granted for a very useful molecule, a pharmaceutical molecule, and it is only that particular molecule which is the blockbuster, and for the next 20 years that is what brings in the money. Look at the technology in areas of information, communication, these areas of technology. For instance, in case of DVD, the number of patents owned by various people, various companies, amount to more than 25,000, owned by almost 150 companies, which together give a technology platform which can be then commercialized in the market. In such a situation, it becomes extremely important for a patent owner to understand at which stage his invention, his patented invention, has been infringed by another party, and what are the remedies that he can get, and would his seeking that remedy create a problem for him by which he will end up losing money in the market and reputation in the market. There are many examples in India and abroad which gives a very clear indication as to how a bona fide patent owner can suffer adversely when he takes a matter to court by way of losing money or by way of losing business or even by way of losing reputation. In some cases, when he files a suit against his opponent, which is usually his competitor, he gives so much of significance and importance and media coverage to the opponent or his competitor that the competitor actually ends up getting far more in return than a mere damages or injunction would harm him. So there are many cases which you can look at it, and one which comes straight to mind is that of Apple versus Samsung. Samsung suddenly became very important player in the mobile phone market thanks to this particular litigation which ranged across multiple countries on many jurisdictions across the world. So it is a matter of a business decision for a patent owner as to whether he wants to seek remedy by way of approaching courts or seek a remedy by way of negotiating a deal and settling the matter between the infringer with the infringer. To just capture another point before we go on to the remedies that are available, the patent applicant or the owner is usually the inventor. Under the Indian law, it can also be the assignee of the inventor. So, if the inventor has assigned his rights to a company, the company is the patent owner. The rights can also devolve, the patent rights can also devolve to the legal heir of the patent owner. So, if there was a person who had a patent right and he was a patent holder, on his demise, the rights by operation of law can devolve to his legal heir and he becomes the patent owner. There is another angle to this, and that comes through voluntary license. The reason I say voluntary license and the reason why I bring it into this patent law remedies is because the patent law very clearly gives rights to the exclusive licensee to sue, just like he is the patent owner. This is very interesting. So, we are talking about an exclusive license holder, and as you understand, an exclusive licensee and a non-exclusive licensee. The difference between the two is, in case of an exclusive license, the exclusive licensee excludes even the patent owner from having rights to exercise his rights. When the patent license, the exclusive license comes to an end, the right goes back to the patent owner. But during the term or the existence of the exclusive patent license, the exclusive licensee has a right to exercise all the patent rights enshrined in section 48 and can exclude even the patent owner. And the Patent Act of 1970 very clearly gives rights to the exclusive licensee to also seek remedy wherever there is a problem. And therefore, it is very important to understand that a patent owner can also be, for purposes of seeking remedy, the exclusive licensee. And it's very interesting, when an exclusive licensee sues and he finds that the patent owner is not interested in pursuing the matter, then the exclusive licensee can name the patent owner as the defendant also. That means, in the memo of parties which he files in the court, you will have the main defendant, the defendant number 1, the one who is infringing, and the last defendant would be the patent owner, and this is just for purposes of executing or for the purposes of seeking a remedy.